Welcome to Legacy Sips and Tips podcast with your geeky host, Lindsay Wheeler, where we talk about everything from death, preparing for your future through estate planning, life, the occasional breakup, entrepreneurship, general nerdery, and of course travel, snowboard, and always wine. Welcome to Legacy Sips and Tips with your host, Lindsay Wheeler, and today we're going to talk about what the F is an estate plan and why do you need one. Let's start with what exactly is a will. So all of us are kind of familiar with a will. We have seen movies, maybe we've heard about it, of that last will and testament, that it's a very important, crazy document that, is very ethereal in the sense of, and very formal of, and so there's bequeath this and there's bequeath that, and my executor shall do this. That's not really how they work anymore. All it is a written document that tells the court what your wishes are after you have passed away. So again, with a will, it's the very minimum you should have because at least it gives direction of what you want, but your heirs are still going to have to go through that probate process or that court process with that will. How we avoid all of that is with our trust or revocable living trust and estate plan. So let's start with a will. A will is a written and attested document that provides your wishes to the court of what happens to your stuff after you have passed away. That's all it is. When we say a written document, that means it's usually typed up or it can be handwritten, which we call a holographic will, and it is signed by you, which is attested by yourself, a notary, and 2 witnesses in most states. The 2 witnesses are that double attestation clause, or if you will, or signing. It is a first witness witnessing you sign, and the second witness is witnessing the witness you. Yeah, that's how that works. So that's usually the general requirement, making sure that if you are going to just do a will and you have those 2 witnesses, that they sign all together with you. You are of sound body and mind, if you will. You're in cognitive health, that you understand what you're signing. Those witnesses are not related to you in any way, because that might be some undue influence, obviously. And with that, they're going to sign in front of a notary. When they sign in front of a notary, they're also going to put their full name, their signature, and their full address. So make sure that full address is on there as well. That is a requirement typically to make it a valid signed will. From there, that's great. However, that is just the roadmap for the court to follow through the probate process. Probate is the court action or the court process of handling dead people's things. That's all it is. It is the societal's checks and balances for dead people's things, because we don't want people's things to go to people that should not have them. It's our society's checks and balances that lock down someone's life when they pass away, and this is the process of unlocking that life and having those items go where they should go. So basically, it's because of, if someone passes away, they don't want some random dude being like, oh, I'm Bob Smith's daughter, I should get his entire account. No, who are you? Let's make sure that you are Bob Smith's daughter. Let's make sure that you are entitled to it all. Let's make sure that, maybe if he does have a will, that he wanted it to go to you in the first place. Okay. So that's what the probate process is. It's the court's checks and balances. They are doing their due diligence to double check that Bob Smith is who he was. You as Jane Smith are the daughter and are entitled to all this. Maybe you have Sally Smith as your sister and you're trying to push her out of the way and have her not get any of that. So that's why it's important for the court to make sure that these things are done on the correct format and manner. With that, of course, when you pass away, your creditors are still going to come after your estate as well. So when you pass away, your debts still have to be paid. That's part of the probate process as well, that your executor, if you have a will, or your personal representative that is appointed by the court, can handle all of these aspects of your life for you after you're not here. So essentially, they will sum zero your life, make sure everything is taken care of, and then marshal all of your assets into one spot, and then that distribution happens from there. With that being said, a fast probate typically is around 13 months. Let that sink in. 13 months is a pretty quick probate. That means when you pass away, your assets get locked down because, again, we don't want random people coming in stealing your stuff. But it takes time for the court to do its due diligence to make sure that those assets should be unlocked and distributed or used to handle your affairs. That's why it takes so long. So with that, when you pass away, your stuff does lock down and no one has access to that. So if they have to pay for your funeral, they're paying that out of their pocket. If you have a mortgage on your house, they're paying that out of their pocket. And I don't know about you, but I can't cover 2 mortgages. So don't do that to your heirs. Your other bills have to be paid for. They're having to take care of your creditors. They're having to take care of, your animals or whatever it is. They're having to take care of your life as if you were here, but without your funds to do so. They're covering those costs. I have one client right now with our probate, and he's like, when am I going to have access to this money? He's like, I've put out $14,000 to date so far, and that was only 2 months in because of all the bills that still had to be paid. And the mortgage company doesn't care that you've passed away. They will foreclose on your house if you stop payment. So it's really important for your heirs to keep continually to pay on those assets to make sure that they don't get seized, closed down, or foreclosed on in the event that you're not here. So with that, that's a nightmare. You're having to then hire an attorney who's usually some schmarmy attorney who's going to be a probate attorney, and they're going to file all these things for you. So not only has somebody passed away, which is traumatic and difficult enough as it is, you're grieving. You're now having to go into an attorney's office. They're going to have to be digging through paperwork. You're going to have to look for everything if things are not set up for you as a successor, as an administrator of this estate. You're going to have to find all this paperwork. You're going to have to get the death certificate. You're going to have to order a funeral and a burial, and then pay this mortgage on top of it if they have a house. That's stressful. You're going to have to then pay this attorney to deal with all these things. And guess what? An attorney is going to take usually 10 to 15% of the entire estate's amount. So think about that. You have a house, you have some investments that didn't have a beneficiary on them, you have some accounts, maybe some vehicles that didn't have beneficiaries on them. With the way that house prices are right now, maybe at the end of the day you have $1 million estate. I know it sounds crazy that you would have $1 million estate, but a lot of these, houses these days are super expensive. Even a basic tract home is around $500,000. So say you have that going for you. You have $1 million house, and now this attorney is somehow going to take 10 to 15% of that. They're taking a percentage of someone's life. That's crazy to me. The way that you can avoid that happening is through the beautiful mechanism we call an estate plan or irrevocable living trust. There are other estate planning vehicles and trusts, but I only focus on revocable living trust because I feel like they give the most ability and flexibility and power to deal with the assets. So that's how we avoid the nightmare of probate, that 13 plus months, the going to the attorney's office, the paying the 10 to 15%, the anguish of having to cover all these things. You are now doing that for your loved ones. You are creating this revocable living trust and putting all of those mechanisms in place ahead of time for your heirs. That's why we don't have to go through probate technically, because you have already done the probate work for us. Now that's the great thing about a revocable living trust. So with that, a full estate plan would typically include many different documents. So an estate plan is not just for when you pass away, it is for your lifetime as well. So if you become ill, if you become incapacitated, if you become a little nutty, you're not really with us anymore, the estate plan handles those aspects of your life as well. So it's a full life document, if you will. So the first thing that you should always be aware of in an estate plan, whether you come to us for it or you hire somebody or you do it yourself or whatever, this is what should be included in an estate plan. If these documents are missing, question that practitioner or question what you're looking at, because these should be all included in there. The first document, of course, is your actual trust agreement itself. That's the playbook or your business plan for your life, if you will, that sets out the rules and conditions of what happens while you're alive and incapacitated or have passed away. So within that, you name who you want to administer your estate for you. That's what we call a successor trustee. Typically, maybe children, your spouse, or a close friend, or even financial institutions. You can have independent authority or businesses to handle those assets or those aspects of your estate plan for you when you're not here. The administration of your life, if you will. With that, we used to like to go 3 down. So if that first successor is not available, who's going to be the backup? And then from there, if they're not available, who's the backup from there? If it's a marital trust, of course, you guys are always for each other. And then if both of you are not available or with us, then where would it go? Who's going to manage that for you? And if they're not available, who's then after that? With that, then we put in, if you have underage children, who's going to take care of those underage children? This is your guardianship nomination. This is very important because we don't want those kids to end up with great Aunt Tess, who's not the best fit to raise these children. Maybe you wanted your best friend who lives down the street to raise your children for you. So that's where you'd put your guardianship nomination in there for your children. Again, usually going down 3 steps from there. Don't list married couples together. Have them broken out, because what if they got divorced at some point and you didn't know about it? Then potentially they would have to be jointly raising these children when they're not jointly together anymore. Then from there, where do you want your stuff to go? That's your distribution. That's where we think about, oh, I bequeath my Hot Wheels set to Bob, whatever it is. Mainly for our big ticket items. We sell the house, we consolidate the accounts, we consolidate your insurances or your investments if you have them all listed as a trust as a beneficiary. And now we have one big pot. Where's that pot going to go? You tell us. You want it equally between your children? Great. You want it if your children are not available, or if they pass away, to their children. If they're not available, then it goes to your siblings or whatever it is. You can be as vague of that, if you will, that the entire estate goes to so-and-so, or you can drill it down and be as specific as you want to. You can put parameters in there that, the house goes to Bob for his lifetime until he decides to move or passes away. So you can provide for those things too. You can put parameters for your underage children or even your older children that upon 18, they only get a certain percentage for reasonable education expenses. At 25, if they want to continue their education or start a business or put it down on a house, that they get a certain percentage at that point. At 30, maybe we hope they're responsible and they can get the full amount at that point. I have one client right now whose son is an older adult. He's in his early 40s, but he's not so good with money. And so they're going to make sure that he's taken care of and doesn't just squander it if they pass away. That every year on his birthday, he gets 10% of that estate plan until it's exhausted. Great, right? Helping to set him up even when they're not here. Same thing with those underage children, because we don't want an 18-year-old getting $500,000 because we're all getting Lamborghinis at that point. So making sure that you can still govern your life from beyond the grave. You can still parent your children from beyond the grave, which is super cool. So that's the first document that's involved. From there, we have our assignment of digital assets, because we live in a digital world of where those digital assets are going to go. We're saying that the trust is going to be able to manage those digital assets. Same thing with our personal property, things like our wine glasses. Delicious. Our wine collection, whatever it is, personal items that don't have titles are going to go to the trust to be managed by the trust. Then we have, if you live in a community property state, we have a community property agreement if you are married in a community property state and doing a marital trust. And then that is your actual trust portion of your estate plan. With that, we have a document called, the next document is called a certificate of trust. And that's the Reader's Digest version of that trust agreement, because that trust agreement is usually around 30 pages or so, depending. Nobody wants to read 30 pages. Also, there's some private information in that estate plan or that trust agreement that financial institutions don't need to see. So that's why we have a certificate of trust. It's the Reader's Digest version, or all the salient information that any kind of financial institution would need to see to set up accounts or to set up beneficiary designations. It'll have who you are, what we're going to call the trust, who's going to manage the trust, and how they manage it. So nothing crazy in there, no real big surprises, if you will. Also, that's another cool thing about your trust or revocable living trust. You can name it whatever you want. That's fun. Most people opt for their last name or their names. Mine's my game handle because I'm a nerd. Whatever you want it to be, you can have fun with that. Okay. From there, that's your trust portion of your estate plan. Then we go into what we call a pour-over will. And you'll say, well, Lindsay, I don't need a will. Those are bad. Those make me go through probate. And I say, that's correct. Thank you for listening. However, a pour-over will is a different type of will. So it's a very important document, but should never have to be used, because you're going to make sure that everything gets transferred or listed as a beneficiary to the trust. The pour-over will is kind of a catch-all document. It'll say who you are, if you're married or not, if you have children, so it'll give that identifying information, and then it'll have the distribution section, and that will say to the trust. So again, it's that catch-all that maybe a bank account got inadvertently left out, something messed up with the title company and they didn't put the house back into the trust after being refinanced. That document will be used to do a quick petition with the court saying, hey, this person, Sue Smith, had a trust. She did not want us to have to go through probate. Hey, court, pour it back into the trust so we don't have to go through probate. So we can manage this asset through the estate plan and through the revocable living trust. So again, very important document, but should never have to be used because we're going to make sure that we fund or transfer those assets accordingly or list the trust in those assets. Okay. Today's episode, we are featuring Blue Oak Vineyards from Coombsville, Napa. So fancy. So we got a Napa theme lately. This is a fantastic wine, actually. This is their Merlot, and this is it's not a cheap bottle, but it's not expensive. Like it's around like the $70, $80 mark. Great bottle of wine. This is if you want somebody who likes wine and you want to give them a really nice fancy gift, they're going to love this. So really nice, this Merlot. I love this one. This one's a limited run. It's only 200 cases were produced. It's got that beautiful Merlot taste to it. I don't know if Merlot has a taste like that, but it does, of course, because all wines do. I really like it. Big, heavy jam in it. A little bit of pepper in that back. And yeah, solid wine. So if you guys are interested, let me know. Next section in all of that is our powers of attorney. So powers of attorney live when we live. When they die or we die, they die with us. So these are for incapacity situations, if you will, or maybe you're not geographically available to take care of these things and you need somebody to step into your shoes to take care of these things for you. There are two different types. We have our financial power of attorney and we have a medical power of attorney. So of course, the first one is our financial decisions while we're alive but unable to make those decisions for us. Paying the bills, paying the mortgage, paying taxes, opening our mail, canceling or using credit cards, whatever it is in there. Our financial aspects, we can give that authority to somebody to act in our shoes while we're unable to do so. There are two ways that becomes active. One is what we call a durable power of attorney, which you may have heard of that term. Durable means now. Regardless of your ability to take care of these things, regardless of your mental or emotional state, physical state. So, you're a young 30-year-old and you have a durable power of attorney. You can literally hand that document to Bob Smith if you name him as your agent, and he can go ahead and take care of those things for you right now. Some people like that quick accessibility if there's an issue. Maybe for me, I have mine as durable because I might be mentally or physically able to make these decisions or take care of these things, but I might be geographically removed because I might be in a foreign country and I'm not able to get to the bank, U.S. Bank here in Nevada, or whatever it is. I'm having the ability for them to take care of that for me right away if they needed to in any kind of circumstance. The other option that people like is called springing. Springing is that before that document would be able to be used by your agent, they would need to first get a doctor to certify you are unable to make those decisions or to advocate for yourself before it would spring into action. That's why it's called springing. So those are those two options of how that document becomes valid and working in your inability to do so. With that, then we have our medical power of attorney, and that is always durable because we want that to be always available for our medical wishes and directives. With those, they will have, salient questions about your medical care. This is like our do not resuscitates or pulling the plug. Do you want to be kept going with our medical technology if you're in a coma and not expected to come out of it? Do you want them to keep you going if you have a terminal condition? What about pain relieving medication? Do you want that? And how do you feel about these situations? How important is it for you to be independent? How important is it for you to be mentally there? How important is it for them to check with your family before these medical providers do these medical procedures? Do they need to check with your friends? You can put all of these in there in that medical power of attorney to give direction to medical personnel of what you want to have done with your stuff. Or with you, I should say. This becomes important in the sense of, do you want to be kept going or not? A lot of times, most of the time, the default for our medical professionals is to keep you going as long as possible because they don't want to be sued for doing something wrong, right? But if you give them a document that says, no, if I have a heart attack or I'm in a coma after 2 weeks or whatever, pull it. Doctors are like, great, I have the instructions, I have the authority to do that without hopefully that repercussion of not doing something correctly. So that's the medical power of attorney there. In that same vein, we have what we call a living will. And I have a lot of people come to me and they're like, oh, I need a living will. And I'm like, ooh, you need a medical directive? Because that's what that is. It's not the typical will like we think about, again, that so-and-so gets these things. A living will is a medical directive of basically, it's your DNRs. Do you want to be resuscitated or not? So that is saying, hey, if a certain circumstance happens, I do not want my doctor to do anything that would prolong my passing or to keep me going past my natural state of passing. Or I do want them to do that. I do want them to keep me going as long as possible. Do you want that artificial nutrition or hydration as well? So that's included too. So that's an important document. That document and the pour over will are technically wills, so they still have that requirement of those two witnesses signing with that notary. So keep that in mind. With that, we also have our burial or cremation instructions, pre-purchase plots, military plots, Neptune Society, composting, whatever it is. Give information of where you want to go, or if you've pre-purchased these things for your heirs, that's a nice gift that you can give for them, is locking in today's rates to take care of that for yourself, for them, so they don't have to upfront those costs. You've already done that for them. And a very important document in this section is our declaration of remains. That gives the person that you have listed the ability to order that for you. So to collect you from the ME's office, the medical examiners, transfer you over to the funeral home or mortuary, that gives them the authority to do so for you. So very important there. We also have our HIPAA release that gives medical professionals the ability to give or release your medical information to whoever you've delineated there to. So that is your estate plan in a nutshell. Quite a few documents going on there. If those are not included in any kind of estate plan that someone you're looking at or shopping at or an attorney's office, then maybe question them, maybe go back, see why they're not included, or be sure that those are included, because that gives you a full estate plan and all the documents that you're going to need for your life for that. With that being said, once you have that all in place, you've done a good job. Now you have the responsibility to fund the trust, as we call it. That is actually physically transferring those assets to your estate plan. It's not enough just to list them. You have to physically go to these institutions and have either them titled into the trust or the designated beneficiary listed as the trust. Okay? Very important part that a lot of people miss. That they're like, Yahoo, I have my estate plan, look at me, I got the little fancy binder. Cool, you have a really nice expensive paperweight. We need to now actually make it functional and transfer those assets into that estate plan. It's just like that ice cream shop that you are forming a business, you have an ice cream shop, you're going to put all of your assets into the ice cream shop. That's you physically transferring them. And then if you're not able to manage your ice cream shop, that's where your successor trustee comes in and manages it for you, because you have already given the assets to your ice cream shop or your trust, and they're able to manage it accordingly from there. So very important there. If you guys have questions, just let me know. I'm happy to discuss this all day long about getting you guys set up and what an estate plan is and why we like to avoid probate, because it sucks. Nightmare of nightmares is probate. And just talk to anybody who's ever gone through one. They just go, oh, that was the worst experience of my life. So we can help you avoid all of that, get you set up, or help your loved ones get that set up for them so you're not having to deal with that. And if you have questions, just let me know. Of course, always I'm at yourestateplan.online or High Sierra Legal. And of course, when you think of death, think of me. Thank you for listening to this podcast. If you found value, please like, subscribe, and share. And be sure to follow me on all the socials at Sips and Tips with Lindsay. And of course, you can always go to my website, sipsandtipswithlindsay.com, to find more information about estate planning, business, snowboard, travel, and of course, wine. As always, we have to get the legal stuff out of the way. I went to law school, so you don't have to. However, we have to read the special disclaimer that I am not a practicing attorney. I am not your attorney. I am not offering any legal advice in any content or any episode. All content is for your information and educational purposes only. It is not a substitute for seeking your own legal advice from your own attorney or other professionals such as a CPA or financial advisor. I cannot give legal advice and do not offer any legal services or legal advice, but I do offer some fun and educational content for you to enjoy.